Mame fa say ma PENDREAM TV. PENDREAM TV de o se dem yopo.
Yewra chama wuntumi versus the state, the republic. E wasem e de ewanimsem. Wo ma kan asem no akodu baabi na court ni say obi am filing addresses. Wo mo be filing addresses na one and the lawyer Yewra and the appeal could be say one of the niema be a course so up to the time is obi am filing addresses no what tia see ye you watching who e de film. Eti watwe ni wu di free mu a kiki no a ye benya Yewra atachia se wono na ababesom wono zo pray court no se oma ne bre mani rem na on fan addresses no said this here and now order and court no can say on or before 13th of this month atwam na what addresses in the Kyea yensa ka bie the ensaka bie no the womu ne say was niema bi wo wa here constitutional interpretation enti ebeya court ni stay judgment na eba so Monday no na o stay court na a judgment eba so Monday na no court no akọ Supreme Court over the interpretation of certain provisions a Minerals and Mining Act nim wadawuma na yenya disua ewomu we eye bibia eye normal practice wo ye jurisprudence mu anase we bibia eye alien to more practices and rules ni ade
yo bra kwame the bia the American is a hard case makes good law but so no a harder. That's when the law develops. Who say one of the things at a personal level, make I say Emrana me NCA Matano. I'm here counsel for the second accused, the then DG, former DG for National Communication Authority. No, a similar thing is here. Emma. At a point, not the way I not try no air corner. I didn't like it. In China's application and call before the judge. Manchama and Yoma I ended. The first time almost first prosecution witness, I mean who said one or two things air corner. One aja made applications now started airba. Inti nyame eyadom ema judge no ehue because that time no near kokota tema sebu prosecution witness for the document ba right there and there na judge say counsel, do you have any objection to the tendering in of this document through prosecution witness 1? After my court, my client's honor in open court, I could be some as a client. Documents where I'm seeing it the first time. Do you want me to raise any objection to it? Is it something that we can rely on? Is it something that is authentic? So the whole thing looks bizarre. Because even in criminal civil trial, there are no surprises. In tobacco, now it has said immediately, for application, I mean, my Lord Justice, stay back for.
Counsel!
Yes, sir.
Where do you buy Metwasia? Senkane any document to be any doubt to be wa sabrana prosecution no hono na defense no so ewo hono na wo mu di asem maybe case management level kra no bibi wo wa esese afani nyina eti asem boa
no correct. When we say section 6 of the Evidence Act NRCD 323 I say admissibility objections should be taken at the time the evidence is being offered.
Maybe I try section 7 is here.
Section 6 of NRCD 323.
Okay. Bajo me kind
Ghana have a friend of the Evidence Act.
Bajo me kind is here. Says Evidence Decree 1975 NRCD 323 Section 6. In every action and at every stage thereof, any objection to the objections admissibility of evidence by a party affected thereby shall be made at the time the evidence is offered. Shall
mandatory. Mandatory.
Yeah.
You know sana msedabi adi mi kana yuyan samakasa na beli into wa me kai Sunday na me friend me other lawyers no because there were other accused persons and say hey before this is what I want to do because the way I know my kono ya nhweni ya yehuni ye into wana ada me application me the bajaj na ni me buy Tuesday na case me here Tuesday Thursday. If you go Tuesday and upon 10 and upon 2 p.m. 4 hours. If every week be near 8 hours solid. If me say I me say I did not encourage me to an amount in a me 2 years. Thankfully, my Lord Justice Kyea for a court of appeal judge now. Over the wisdom in it, I make a tell me say, my Lord, me say oh, an idiom. Try ye. Yan sheni ya. Then as lawyers, you may be a client in trouble. Quality legal representation is here far more. Yes, mean far more. Because Section 6, I need to take an objection.
Okay,
because this is the time we are offering the evidence. Now, I am not seeing the document. If the question soon I make me take a proper objection on a document I'm seeing the first time.
Na Bajawasa can says to every objection to the admissibility of evidence shall be recorded, ruled upon by the court as a matter of course.
Absolutely. Don't come in. I go back, no. My law is okay. Application here, there. And let me say, look, Article 19, Fair Trial Rules, may say, an accused person should be given reasonable opportunity to prepare his defense. It is one American say, my Lord, with the greatest of respect. The Constitution and the use of that word, reasonable opportunity to prepare the defense, no. That prepared defense, no, a very broad concept. The European Union, this particular provision, no, the 1992 Constitution, we are taken from other statutes.
I the 19 was that the idea was say one no say a person charged with criminal offense.
No, they are 19.2.
A person charged with criminal offense shall in the case of an offense other than high treason or treason, the punishment for which is death or imprisonment for life, be tried by a judge and jury.
They are called 2C.
2C, okay. Be presumed to be innocent until he is proved or has pleaded guilty.
Now Yenko D.
D. See, be informed immediately in a language he understands and in detail of the nature of the offense charged.
Fantastic. Now G. G,
okay. Okay, G say, be afforded facilities to examine.
Wait. Be afforded what?
Facilities. To be to examine in person or by his lawyer the witness called by the proceeding before the court.
Afforded facilities to examine. That word, afforded facilities. You didn't catch the court then say Constitution using the word afforded facilities to examine. It includes documents. Facility no yet ni pankwa. It includes documents. the examination of those documents, what means for mommy to see and cast me examine? It may make us say the 1992 Constitution in use of the word facilities to examine, it includes let me know ahead of time what you have so I can do proper examination.
And mommy surprises be in court.
When mommy surprises be two, Rakwame. Me know neko, we are buying. I wouldn't say buying say strong, mighty. I buy no echo. Now I buy a keep it documents. Rakwame, what I say? I buy documents, no. In the last minute, what the other spring you on me. And also the heading of that constitutional provision, then fair trial. And
say na how was it? Fair trial, yes.
Fair trial. Now, Brokami, how can that trial be fair? And what time or you are blindfolded me? It doesn't make sense. Even though at that time the Attorney General of that time, Madam Gloria Kufu, any team ever court. And Brana me moving my application. Almost said there be minimum crisis mechanism. No, there be the Criminal Procedure Act at 30 has only 2 forms of trial.
The whole Chief Justice in by.
No, Attorney General.
Attorney General, in any case, is a case of national interest, pa.
Yes. Yeah, Mami Gloria Kufu. So she was in court, she was announced just that my law lecturer, my criminal procedure lecturer, Madam Evelyn Kilson, on the opposite application. So that be at the Amede Bano, that is not how the criminal trial system is. That be because there are 2 modes of trial. And
not just procedural, the only money defective and answer a dear baby.
No, the Amede Bano, that is not the law. Parliament, at 30, Parliament created 2 modes of trial, summary trial and trial on indictment. Now, say a trial on indictment, they would have disclosed the documents and the evidence they have. But because it's a summary trial, the Act 30 does not give them that. And I said, no, Act 30 was done in 1960. I'm talking about 1992 Constitution. And the provisions in the 1992 Constitution. If you want me to use Act 30 as the basis to say, there is no such thing. Thankfully, the judge in question, my Lord Kyea, saw the wisdom in what the prayer had made. If you want to look, only me arguing. But since maybe meaning Article 130, Article 19, 2G, no. In a Attorney General so can say, the American, that is not how it is, no. That day, I say, I not tell me so, but Mr. Tamaklo, you do know that Article 19 is a human rights provision. So as a judge sitting here, I have the mandate under Article 33 to enforce human rights provisions. Now, Mr. My Lord, if you look carefully at Article 132, Article 132, then the honor. And the law. Article 132,
Article
132.
But Article 132, the what one where an issue that relates to a matter or question referred to in a clause 1 of this article arises in any proceedings in a court other than the Supreme Court, that court shall stay the proceedings and refer the question of law involved to the Supreme Court for determination, and the court in which the question arose shall dispose of the case in accordance with the decision of the Supreme Court.
So that's it. And see, Article 132, they say, 1992 Constitution, Emma the Supreme Court exclusive original jurisdiction to interpret the Constitution. However, it can happen, say, as a matter so in their district court, circuit court, court of appeal, and now say at the way send a friend at the High Court, what I say, or even Court of Appeal. Now, a Kobase said there's a matter going on at the High Court, Court of Appeal, Circuit Court, District Court. Now, the parties involved, but the parties involved are raising an issue that clearly you can see that there is a genuine interpretation. High Court and now Court of Appeal are no AC, no. So, men to Anamobia, Jinawa, Nasa system no bra, young na Supreme Court for honor. Now, the Supreme Court, a interpretation, said you at that time, no, yet the Bebreo na way to go and more. Rakame, Mekai, say, young law firm, you represent Zoom Lion. Auditor General, SHRG Zoom Lion, say, Sikabia Yetuama Zoom Lion, it was unlawfully paid. Into say Zoom Lion, surcharge and disallowance. So in the powers of the Auditor General to surcharge and disallow. But the Audit Service Act, I can say, so be dissatisfied with the disallowance and surcharge. The person has a right of appeal to the High Court. It's a Zoom Lion called High Court. Oko High Court, na High Court, so only in Yejuma, and Yaji, na disallowance near proper. So from there, we appeal to the Court of Appeal. Now, you do Court of Appeal, no? It is really a constitutional matter at the Court of Appeal. Say, the Auditor General's power to surcharge and disallowance, no, and limited in scope. Back forth. When we made the prayer, the Court of Appeal agreed and referred the matter to the Supreme Court. That's one. Rakwame, so you say, me and me is an actual case in the man.
Sure,
So that time, Nami and Senior Gary Nimako, a lawyer for the plaintiffs. And now, the rates are all issue here. No, we will say relief one. The relief one, no. The way are drafting, no, and now all catching the relief one, no. Or say, the defendant, within the meaning of Article 94(2)(c), is not qualified to be a member, blah, 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 blah. It is way and say, Article 94(2)(c), relief one, no, about, no. As far as I'm concerned, only kicks in if the Electoral Commission opens nominations. At the time, Omodia said no buy, no contention, and he said, when my client and a registered voter.
Yes,
within the meaning of Article 94(2)(c). And I make a said Article 94(2)(c) no only comes in if the Electoral Commission had open nomination, and by that time she is not a registered voter, then she is bad. Okay, and now on for a Procedural, President Rawlings appointed the first time as minister. No, he came out and said he was not a registered voter in 1992.
Yes,
and ministerial appointment was withdrawn. Until say 96, we no buy 96 election no buy registered voter, and Sir President Rawlings the Minister of Education or Communication later.
Yeah.
Then we can say those constitutional provisions, 94, no, only kicks in if nominations have been opened and the person is not qualified. But at the time, my senior Gary Eddie rate no buy, on behalf of the plaintiffs, no. Not only the NDC internal primaries had happened. And I'm saying no. If the issue is about being a registered voter, then there's an opportunity for limited registration, by which time she could have been registered before the Electoral Commission will open nomination.
It's a limited registration, but now I'm going to register, dear.
And yes, I am no better no. Now, the call. I remember vividly, we had appeared, so the writ was before my Lord Justice Akabwafo. That time, not a High Court judge, now a Supreme Court judge. It's the one I mean, yes, man can't crow. And I'm raising preliminary legal objection. And I'm saying, my Lord, with respect, what's really one of the plaintiff case now? Also within the meaning, it means that on the interpretation they are total. And I'm saying, my Lord, as far as Article 132 is concerned, you can't hear this matter. You must stay and refer it to the Supreme Court. And Article 132 is mandatory. It says, shall stay and refer. It make us, oh, my Lord, so the American, that is not it. As a High Court judge, Mankasa. So he gave a ruling on my application. One Abrakwame, me yes, Shurarai. I invoke the supervisory jurisdiction of the Supreme Court. It means invoking the supervisory jurisdiction of the Supreme Court, no. In a Supreme Court by a 4-1 majority decision. Mekai Pa, my Lord Justice Eniobwa, at that time, dissented. But the remaining 4 agreed with me and referred the matter to themselves.
Court of Batan has not departed from
no.
their earlier ruling. Yeah.
That decision, that Senator decision today has set the rule on parliamentary election contest and qualification. Mekai Krasi, it was even reported in the Supreme Court of Ghana law report. The reason why I'm bringing all of these instances, I want you to appreciate how the Constitution and how the lower courts have operated over time. Now, there's an interesting decision by the Supreme Court of Ghana.
Kabila.
It will show the case of the Kwabena Bonfe and Attorney General 2019-2021 Supreme Court law report. This is what the Supreme Court said. The real test as to whether there is an issue of constitutional interpretation is whether the words in the constitutional provisions the court is invited to interpret are ambiguous, imprecise, unclear, and cannot be applied unless interpreted. If it were otherwise, every conceivable case may originate in the Supreme Court by stretch of human ingenuity and the manipulation of language to raise a tangible constitutional question. Practically, every justiciable issue can be spun to such a way as to embrace some tangible constitutional interpretation. In the Supreme Court, in this Kwabena Bonfe and Attorney General, this is say, Sebio, a lawyer for you, very ingenious people. Omaji running very, very fast. Into 1 year, the Supreme Court will become the forum for every issue because at every point in time, lawyer need be a bit work. I see interpretation in it. And when the lawyer has said so, no, it means whatever the matter is happening, the judge would have to state the matter and refer to the Supreme Court. So that is what the Supreme Court appears to be saying in the Kwabena Bonfe versus Attorney General decision. Brother, when we say the senior, and you can never take away ingenuity from senior Atta. As
As a baby, your mommy, why? DJ Diomi mami na yenko anim na afena ya kire mra no awie eti ya de ba case no ankasa wo mo de akodan court no woni wa
bacho afro hini wa wa na to no hini wa ni wa asa afeno yambo cha do
afena woni na suntre mu se
me na sunche mu se enya hwe mi ni anti a ai woni di machi
na muni dia mo asunte mu eye
debut
esa asumbo pa
mi na asunte mu se na ye nya boni bia en kan na asunte mu sa asumbo
ai obi bo wasuma ede mama sa ngomda kazo memo kwabo
Kwa me asema wo kan ye no means obi ambo wasunda. You know, Obina, all kinds you, the wise say you need to get your enemies closer. You know, Nipano responding say it depends on the number of enemies that you have. If you have a lot of enemies, you can't get them closer. As a trono, it depends on the one or the.
Na I wouldn't say SMBC Bible moi. E be pem na meti ase enye yi. Odifo. E na oka kire ne yonko difo se. Awurade ayi a kire me se bomasum. Wa momasum a ufiri akopɛ jata be chiwo ama ario. Osa na me de bare na mabosum. Winza ofiri wo koye na jata ekwache ne we
anya kwanse na wenti sometimes our concern be look so unreasonable but just respect it and do it, you know.
Akonso ye wo ye nzo nyankwa
back to the discussion now you know. Now me can say me senior judge here is an established legal guru. You can't take that away from him. Mehu publications online. It's may address to the court while raising some important constitutional issues in the address. And Brother Kwame, it makes very interesting, very, very interesting reading, and quite interesting, very, very interesting. Why do I say it's very interesting? Oshaya, the offenses against Chairman Wintumi involves the Minerals and Mining Act. Now, Black one, when we say the previous Minerals and Mining Act, 2019, in our MPP are buying amending, on the core parliament, and when we say at that time, now MPP were about 165 MPs in parliament. I've been advising these political parties, don't make laws out of happiness. Don't make laws out of happiness or to resolve a particular way. You need to think deeply. And at that time, out of every way, we are making an amendment to the Minerals and Mining Act. Abraham, I'll just read what the law says. Section 14. Assignment of mineral rights. Or say, a mineral right shall not in whole or in part be transferred, assigned, mortgaged, or otherwise encumbered, or dealt with in a manner without the prior approval. In writing, but you in what?
In writing.
Writing. So the approval cannot even be by word of mouth. it must be in writing. No, or say, a mineral right shall not, in whole or in part, be assigned, transferred. It will show a quick idea about your man won't mean in say. A mineral right includes the right to possibly do reclamation. Because only concession won't mean reclamation and
Debbie.
But say ubet reclamation on that land no. When you see minister no in writing at the mouth that opportunity. Prosecution a case against chairman and say chairman, it may be true say you have the concession. But a branch you know your friend or Henry Oku and I send your friend okay. Concession also. Now, chairman, what do you say? Who makes me about concession also because said you only can say Obama Henry Oku to me say on your reclamation on the land because a man say who makes me to Sana Mona I just say Minister Emma will approve in writing section 14. That is what it says. Now section 94 of the same Embrano 99 of the same Embrano essay and I with your kind permission mankind or say offenses and penalties. And this was the amendment that was introduced under the NPP. Or say, a person who buys or sells minerals without a license in accordance with so and so, B, a valid authority granted under this act or any other enactment, a valid authority, commits an offense. So, Section 99, no, about the year the office creating provision in the Minerals and Mining Act as amended in 2019.
Ayi council me pamucho 80 so
Metiba
81 pana eye won kwotena ase anwini ade mi kinkan me ba oh session now I say a person the working can you the bar was say a person who buys or sells minerals without a license in accordance with section 6, 82, 97 and 104 or a valid authority granted under this act or any other enactment commits an offense and is liable to a summary conviction to a fine not less than 10,000 penalty units and not more than 15,000 penalty units and to a term of imprisonment not less than 15 years and not more than 25 years.
I never understood the reason for this amendment.
But,
and at that time, no, so a brand new person should say, or person I'm saying, look.
Council, my name for two a person who, without license, granted by the minister, undertakes mine operation contrary to a provision of this act, acts or instigates command counsels, procures, solicits, or in any other purposely aids, facilitate, encourage, and promote any act of Naja say we be kwa banam to for say man in the maya bida with the any ninam Azo
Okay FM 101.7
Azo Kaze Council Sam akwa baby mo emu ye. Council Timenka. Oh, Satra ni bim. Aba.
Emma.
Emrana ye kenkan wa ha no.
Aye.
Eye galams you go to mind we need license.
Aye.
Ena o kire mu se. Obi a bepacho aha kire mu aha ma me ebra ye twa cancel. Obi bo bibi.
And obi bo bibi no efi eche ha. Okay. Come.
Yeah. I say a person who acts or instigates as I just say.
Onipa bia o tu anamo ana oye bibi.
Commands.
O she.
Counsels.
O tufo.
Procures. Procures.
Oto bibi.
Solicits.
O bisa bibi ana ojiji bibi.
Aids.
Obuo bibi.
Facilitate.
Obi ekunu ma ana ma kwanya ebeda ho.
Encourage.
Me who's the main kanimbu.
O shenkwan. Or promotes.
Ana o pia bibi pia mai kwa nkan ana o shebukena.
Wo sa nipa no kra na uka utunfo no ubatimi adam mining act ne yechewa not less than 50 years.
You fita mi no.
Fita bia me na wo commanding wo tu no fo wo ska ka man no
wo shem cry eh utimi dem ha
15 years and not more than 25 years. Me kwa
cobra eh
kaza me samu akwa baby o
Inti pakwa me. Inti in 2019 on deba. Remember license. The provision are encouraged, you know. Sebi. Kukum. Nyame ya wadum na bia sika obeti make.
Okay,
Na bi no obasi we na make me a charge for encourage for instigate it too awful said that. But at that time no the majority in parliament and then we say when yeah it does two things briefly.
Council jababi ye kakrama ye why da ho kakra
entun krama wan se o de oka ubi e wanu ana atiko ubi na mfofo o nya kai dan
there be what pe
afem to say me nka bi we ye oni me ka nam so wan wai ubi e wanu ana o shi atiko
em say no owe mini so em say wa de mini mi do ka bia no o mu di code ato so tu kan nate
hey wow of a minus act in some Rana de law ana act.
Tell na yam.
Anwa amrana. Ai.
Ba ansem sam akwa ba.
Bra kwa me bacho otemenka.
Metonka ye to aso.
Inti de na make no say o share the amendment that was done in 2019 the section 99 no 2 no. I can say a person particularly the D act or instigate, commands, counsels, procures, solicits, or in any manner purposely aid facilitates, encourages, or promotes any act in contravention of a provision of this act commits an offense. Right. Until Ushe Adia Sinatatia Ediato Court now. You all can and say, I want you to go to Article 1911. Then
Article 1911, I mean, me ready, also say, aha. Article 1911, the what true you say, no person shall be convicted of a criminal offense unless the offense is defined and the penalty for it is prescribed in the written law. No person shall be convicted of a crime, a criminal offense, unless the offense is defined and the penalty for it is prescribed in the written law.
Article 1911. Now, okay, together with Article Sections 14 and 99 of the Minerals and Mining Amendment 2019 Emrana. What is promotion? What is encouraging? What is aid? What is facilitate? And then the BOPRA. And so to the extent say, according to him,
Ella also can say section 19 and then 99 no 2 no Ebano must not be read in part. The young kind of the Supreme Court to need to be signal
read together. It means a vague, a broad. Anybody, I say winning petroling.
Petrol, yeah.
Winning petroling.
Bajani.
Omukuyi enam with the big vessels now. Omo the net no back to one vessel. No more the other end they to another vessel. No more enam side by side. So in that point, no, bibi bia sebi ewo that portion of ensuni biano will be cut. Into the upper chain, you know, say, I'm running here broad and vague. A broad and vague. Into what judge, you know, and proceed with those offenses to make a determination unless or court, Emma court, you know, Supreme Court can show the provisions are proper and therefore a charge can be founded on it. The only challenge, and then say, you see, when you put up criminal charges, you are served with criminal charges, and you have an issue with the validity or otherwise of those charges now. You must raise it right from the beginning. Hello, Brakwame.
You are super with you.
You have to raise it right from the beginning. You don't answer to those charges. Because in this case, no, it does.
So one tears here, Sanka, you not answer to those charges.
The issue is that in this particular case, no, the accused person had seen say these charges are proper. Had gone ahead to say I am not guilty. Had gone ahead to offer an explanation. Had called witnesses to say they are more canon. Say your offense to Krana have not committed those offenses. So at this point where you are addressing the court, not at the who raising these issues about vagueness and others are. Baby, sir, at the time you were responding to those charges, what charges were you responding to? Now, Brother, I'll give you a clear instance. And now, Mr. Chachichikata, talk I. Any criminal charges are born. The offenses were causing financial loss to the state. And I'm Mr. Tikata, reading the same Article 1911. I say, there be, if you know, immediately I charges near the bond. You know, that be. I can't even prepare my defense because I don't know what charges I'm facing. What is willful? What is causing financial loss? What's the meaning of those offenses? In no raising those constitutional matters in the Kyea Supreme Court. Another one, Black Kwame. Okay. Journalist and your friend is Tommy Thompson. No?
Oh, Tommy Thompson, yeah, sure.
Free press.
Aye.
Okay, free press.
Kaipa, who say journalism no? Medimuntinti my pa free. 1969, 79, munyina bawo.
Yamisha.
Adabi me chese na menya na meken kan. Omo baka so obi anyi okroma. Aye.
Inti Kyea. Tommy Thompson free press. It shows some horrible story about your mommy Edudzi and rolling. Inti at that time no. Now the Criminal Offences Act no. The Criminal Libel and Seditious Law. Okay.
Ipa almost be the editor of the then Pioneer in 1978. Mr. Atakwejima.
We read here as recent as 1990.
Okay.
And almost your story. F.I.M. Mommy Edudzi and rolling, trying to link her to drug trade among others. Inti Attorney General of that time bringing criminal charges against Tommy Thompson, the Free Press, and Tommy Thompson Company Limited. Say, publication now on my year after Mami Edudzi and Rollins. The borders on criminal libel. And to the extent that those publications were libelous, the Caribbean, they have committed an offense. Do you know who his lawyer was?
No.
Nanado Dankwe Kufuado.
Okay.
Yeah. So Nanado as lawyer for Tommy Thompson, as no court now was I have a preliminary legal objection. At the circuit court, the circuit court said, what objection? No, say no. The 1992 Constitution guarantees free press. It guarantees free press. Now, to the extent to say, this is speech, a journalist, to that extent, you know, Sebio, so we're publishing the Bikrana FOB1. Your only resort for the defamation, it can't be a criminal offense. So, the Criminal Libel and Seditious Law now, Act 29, IA Criminal Offences Act. And in 1992 Constitution, inconsistent. One can try to answer to the charge.
Okay.
Preliminary legal objection was taken immediately, challenging the constitutionality or otherwise.
Yeah, family way swear.
Anything I can say, in this particular instance, maybe this objection to the uprightness or constitutional uprightness of the charges, or the provisions of 14 and 99, possibly, should have been taken much earlier.
Oh, okay.
Before the charges were answered to, before witnesses. Maybe at this point where it is just an address, he will put the accused person possibly in a very tight corner. I think, as part of this, maybe it's a learning that we as lawyers, we are learning from these matters. We are learning from these matters. Mekai, Emrana, me case, Honorable Mahama Yariga, and the special prosecutor. And what charges me by Anna me raising the preliminary legal objection. Then I started the process of this objection until eventually he was even acquitted and discharged. So the point I am making is that the way no is a very attractive legal strategy to adopt. So we await what in the wisdom of the judge obey going forward.
Okay. Eya, mamena was na mi senya mpamfa ma wai.
Dedi kama mamena PENDREAM TV ase. Na so far so good. Say open online portal e wo Ghana. Ah nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.